Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Good morning. Welcome to the Fourth Circuit. Our first case is 24-1898, and we'll hear from Mr. Newell.
May it please the court? It's Michael Newell, of course, for the appellants. The district court confirmed what the appellees themselves called provisional relief, interim award that under the governing arbitration rules cannot prejudice subsequent merit proceedings and requires unanimous party consent to become final. Here, no such consent took place, and therefore, this provisional relief does not meet the standard for a final binding award. Moreover, and what ties into the subsequent arguments, the petition was filed 260 days after the 3-year statute of limitations. And finally, of course, the Dutch orders that are sought to be enforced in North Carolina don't have a money judgment that would meet the North Carolina statute. So first, we would, of course, go back to the argument that this is not binding. There are different steps that could have taken place to create a binding award. But here, it's already been conceded that what was sought was provisional relief. And that is exactly what was achieved, was provisional relief.
I agree that it's labeled provisional relief, but what's your authority for the proposition that it's not nonetheless binding? I mean, so you said the arbitration award is not binding because it is subject to modification. What is your authority for the proposition that it's subject to modification? I did not see that in the NAI rules.
So going to address the point at the outset, the provisional relief that was sought, there is a mechanism for them to seek a binding award at the outset. So I would say the
mechanism is go to court. What is that? Sorry.
So at the outset, they could have sought, and let me make sure I say this correctly, a decision on the merits, all right? At the unanimous request of the parties, they could have sought a decision on the merits or converted the decision from provisional relief to a decision on the merits. So the very mechanism in the court that it was being originally arbitrated, they could have sought to convert this provisional relief to a decision on the merits.
But you keep using the words decision on the merits as if that's the magical words. Aren't the magical words binding on the parties? Isn't that the magical words?
Right.
And why, let me just give you an example. Why isn't, say, a preliminary injunction obviously binding on the parties?
Preliminary.
And why isn't this basically a preliminary injunction?
Well, we would argue that it is separate from a preliminary injunction, and that is one of the things that makes this difficult to parse through, but we would say that the different statutes and rules assist us in making the determination of what's the correct procedure to achieve the outcome they sought.
The only authority I can find is Article 35 of the Dutch NAI rules. It says, it describes an arbitration tribunal's power to grant immediately enforceable provisional relief. Is there any other authority than that rule?
Well, in that rule where they say they can enforce the judgment, which would hold for enforcing the judgment in the Netherlands, essentially, does not create that same mechanism for them to use that same argument to create a binding decision for purposes of the New York Convention. So recognizing what you're saying about it being enforceable, however, that arbitration distinction could be made at any point by a separate arbitral court. It could be enforceable at a separate point, but the United States has addressed this and allowing for the argument that it must be binding. And the different aspects of binding are controlled also by that same 35 and 36.
Well, a treaty, this is done by a treaty. It's enforceable in the Netherlands, and if by treaty, if it's enforceable in the Netherlands, it's enforceable in the United States.
Well, we would argue, going beyond just this part of the argument, that they also exceeded the statute of limitations and the enforceability based on the North Carolina statute is not met.
Well, as
So-
to your statute of limitations, all right, what are we gonna do with Judge Russell's case, which is a public authority? It says it's may file. I don't necessarily agree with it, but we got that case, we're looking this in the eye.
Right. I was looking at that case as well. I think we also have other precedents that address this 3-year statute of limitations.
From
as-
other circuits, right?
From other circuits, that's
Well,
correct.
that doesn't help with Judge Floyd's question.
You're correct, that it is all separate circuits, but I do think the arguments in them are helpful in distinguishing the differences.
Okay, help me complete the following sentence. Despite the fact that this panel is 100% bound by Sverdrup, we can nonetheless reach a different conclusion under this statute because.
Swerdrup
What is the reason that I would say?
Swerdrup addresses Chapter 1.
So it's a different statute, okay.
Right. Whereas sea transport is more on point with addressing the international
Okay, but
treaty
once you
as-
point out it's a different statute, I'm going to point out that that statute is worded not literally the same, but extremely similarly to this statute, right?
It's similar. It is.
Not just more, it's really, again, it's not verbatim, but it is extremely similarly worded, right?
Well, Chapter 2 states, within 3 years after an arbitral award falling under the convention is made, any party to the arbitration may apply. We would say that, of course, that 3 years establishes a temporal boundary, and it specifically ties the awards falling under the convention. It's a treaty implementation provision. It's not just a procedural rule. So the wording, especially when we're getting down to the points of parsing may versus shall versus must, we still have to look at the legislative intent. If it wanted to account for 3 or 4 years or 5 years, there has to be, just as a legislative intent applies, some statute, some temporal boundary. And we run the risk of just making it superfluous that we have a 3-year statute that's mentioned within this.
I mean, the court in Sverdrup seemed to acknowledge that they were making the statute of limitations superfluous and non-existent in that statute. The Supreme Court in Cortez Bird Chip, since then, has said we shouldn't rely on the may-must distinction in the FAA, not in this particular context. They were talking about something else. But does that give you any help in arguing why we should maybe be more cautious?
I think we should be more cautious because we also have mechanisms in place within that 3-year statute under that could essentially stay that time period, so you can still meet that 3-year statute of limitations. All which is in sea transport, which describes how the proper mechanism for meeting your statute, which is wouldn't apply to Chapter 1. In Chapter 1, you wouldn't have the same sorts of hurdles because it refers to domestic awards. But imagine in Chapter 2, dealing with international treaties, there needs to be some mechanism that controls the proper procedure to both meet the statute and make sure the judgments that are still being determined overseas can stay their course as well.
Well, aren't you at a catch-22? It really doesn't matter about the federal arbitration, about the enforceability that way. Doesn't the North Carolina statute catch you either way? There's no statute of limitations. It says that the statute's broad enough to say that these arbitration awards like this one can be enforced. I mean, aren't you kind of caught between a rock and a hard place?
I'm not sure I heard all of that, but
Well, I'm sorry, I didn't
I'm sorry.
speak it. But aren't you kind of caught between a rock and a hard place? It doesn't make any difference arguing about the federal side of this. The North Carolina statute is broad enough and comprehensive enough to catch you, and there's no statute of limitations in that particular enforcement statute.
Well, going to the North Carolina statute as well, and of course you've seen the brief, it would require a judgment that grants or denies a sum of money, specific sum, whereas what is being relied on here simply is still the arbitral award, which the North Carolina statute specifically says the arbitral award.
How did it not grant all of the relief in the arbitral award? I mean, the court in the Netherlands granted enforcement of the arbitral award, attached the award, saying like, this is what we are granting a judgment on. I mean, is your argument that the court needed to actually specify the amount in its document rather than attaching a document and saying that's the amount that there's a judgment in? Or what's your distinction there?
That would be this, a part of the distinction.
So what in the North Carolina law tells me that the court can't say we're entering a judgment as reflected in the attached? Like, what in the North Carolina statute says, no, you have to put the dollar amount, like, in a different spot in the judgment?
I'm sorry. I would argue that the North Carolina statute doesn't say the version of what you just said either.
I agree with that.
Right.
But what's your,
And
how does it support you?
Well, because the proceedings that we're referring to don't go as far as to say that this award specifically attaches the award, yes. But there are still proceedings that are taking place to, where these things can still be changed, essentially. It's not, if they want to make a decision on the merits.
Didn't it go all the way up to the, like, highest court in the country? I mean, how could that be changed now?
Well, what I'm saying is the arbitral award and the things that are taking place in the Netherlands and the Dutch courts are separate and apart from this, also have other mechanisms, decision on merits, or merits-based decisions that did not take place in getting the provisional award.
So this goes back to your argument why you don't think the arbitration award is binding.
Yeah, provisional relief.
But now we're talking about the court, like the Rottingham's court's ruling. Why isn't that binding?
Well, what they will cite doesn't reference provisional awards. Let me say this correctly. They have final awards that are discussed in Rottingham, final awards seeking provisional relief as opposed to provisional awards seeking urgent relief. So it's just distinguished in general that the types of provisional that we're talking about as opposed to the award they have provisional relief now. They didn't get a final award as is distinguished from the cases that they have cited in Rottingham. So without the final award is different than a provisional relief, essentially.
And that affects the application of the North Carolina statute how?
Well, it affects the North Carolina statute, still going back to it, specifically states a judgment of a foreign court confirming or setting aside an arbitral award could be covered. But in this case, arbitral awards themselves are not covered. And that's the only thing that's been established is the arbitral award. Nothing beyond that original arbitral award is what's being discussed and what has already been adjudicated there through the arbitration process. So the distinction would be an arbitral award versus a money judgment. Right. So we're at about the last 25 seconds here. So if there's each one of these items independently, specifically the statute of limitations, I understand that argument of May, but I believe the legislative intent was clear to set a boundary of 3 years for that filing. And thank you for your time.
Thank you, counsel. We'll hear from counsel for appellee.
Good morning, Your Honors. My name is Jeff Olenick. I'm here today representing the appellees together with Kate Gadiz. And we represent the employees who are insolvency practitioners in the Netherlands, and they have been assigned the practitioners to rehabilitate Conservatrix. Conservatrix is an insurance company there. It sells primarily burial and life insurance. That company became insolvent. That resulted in arbitral proceedings that ended with an award against Mr. Lindbergh, Appellant Lindbergh, and the other 4 companies he represents, owns, or controls, requiring them to put money back in, to put 150 million euros into reserves, to make that solvent, to meet the requirements on the Dutch National Bank of being solvent 135% of what's needed in order to pay the claims. What has happened since then is they've now gone on a course of now going on 6 years to try to enforce that award. We come here today to ask this court to affirm the award where they affirm the judgment and the rulings of Judge Eagles in the District Court in the Middle District of North Carolina, that one, that award is binding, two, it's not barred by the statute of limitations, and to get to Judge Floyd's point, sort of in any way, it would be enforceable under the North Carolina Foreign Judgment Recognition Act.
So I have a question about the district court's judgment that I'm
Yeah.
genuinely confused by.
Yes, sir.
So you asked the district court to confirm the arbitral award under both federal and state law, correct?
We did.
In a two-count petition?
Correct.
Okay, so now I'm looking at the district court's order. Which ground did she confirm under?
Well, Your Honor, I should have brought my joint appendix.
I will represent to you
Yeah.
that I will represent to you that the judgment does not actually specify whether this is confirmed under federal law, state law, or both.
And I'll accept that
Why
representation.
isn't that a problem?
Why is it, that a judgment that the.
Well, let me just give you an
Confirmed.
example.
Okay.
That under SEMTEC, the Supreme Court's decision in SEMTEC would say, if the award was confirmed under federal law, its preclusive effect is determined by federal law. But if it was confirmed under state law, SEMTEC says the preclusive effect of that judgment is determined by North Carolina state law. So in order to decide the preclusive effect of this judgment, I have to know if it was confirmed under federal or state law. And based on the district court's order, I don't know which it was. Why isn't that a problem, is the question, I guess.
And if well, I did understand the question, Your Honor, and I think then, on the preclusive effect of federal law, we'd ask that it be affirmed on the federal grounds.
Well, no, but I mean, so literally now you have a judgment, you want to go around enforcing your judgment, and to decide so if you take it to a future court and say, give preclusive effect to this judgment, that court, predictably enough, might have a question, whose preclusion law do I apply? Now, maybe nothing really is at stake in this in most situations, but there may be differences between North Carolina and federal preclusion law.
Your Honor, we have not looked at that, but it seems like we have a judgment for what Judge Eagles determined 150 million euros becomes 167 million dollars US with the federal rate of interest. So I think that would determine what the judgment would be that we would try to enforce.
I mean, she says, the respondents have not established any ground for refusal to confirm the award under the FAA and the convention. And she doesn't address state law at all in that opinion. Why isn't the easy answer, this was under federal law?
And that's what you said. I think we do it under federal law.
So then what was the district court's resolution of the state law request?
Well,
I know the court denied them. There was a motion to dismiss the state law request that the district court denied and basically said, because I think it's wrong.
Right.
So, again, maybe nothing fundamentally turns on this, but it was a real question I had when I read. I was like, you asked for confirmation. So, well, I'll take you to the thing that actually motivated this question.
Yes, sure.
The question was whether or not we could just say it's fine under state law and thus not decide if it's fine under federal law, because, I mean, here's the problem in a nutshell. You have a decision that strongly implies you're right, but it is about a different statute. And I read that decision, and a lot has changed about how we interpret statutes in the intervening years. And when I read that decision, it looks nothing at all like how we interpret statutes now. And I realize that it's completely binding about its interpretation of that statute. But the hard question for me is whether a court that interprets a different statute as meaning X binds us to construe this statute as meaning X, even though it has almost nothing to do with how courts construe statutes in 2025.
Your Honor, binding on the, what I call statute of limitations, may versus
Correct.
must.
Well, but it's a different statute. That case involves a different statute, right?
Right, different statute.
Okay.
And as you point out, Your Honor, that is the controlling decision. I call it sever drop, is controlling decision here.
Well, it's not literally controlling because it doesn't actually involve this statute. So to me, this is basically a question about a conflict between statutory interpretation methodologies and stare decisis. And I just mean genuinely when I say I think this is like a really hard question. And I'm asking for your thoughts on that.
Well, Your Honor, it is the same statute. It's the FAA, and it's Chapter 1
It's a
versus
different
Chapter
provision.
2.
It's not the same
Chapter 1 versus Chapter 2.
Sure, and there is a presumption that similarly worded provisions of the same statute mean the same thing, but it is a presumption. It is not an absolute categorical rule.
But
And
John-
this case doesn't involve literally the same statutory section at issue in that previous case, right?
Right, but you cited the law that says you're supposed to read it consistently within the
Right,
same statute.
because that's a principle of statutory interpretation. But another principle of statutory interpretation is that we read words in accordance with their plain meaning, and I think that decision does not read words in accordance with its plain meaning. And the current rules of statutory interpretation says we don't do a free-form purpose inquiry when the text is clear, but that decision jumps to a really free-form purpose inquiry. And we're really skeptical about legislative history, and that opinion relies on legislative history pretty heavily, as I recall. So, like, it's just not the way we interpret federal statutes now, at all.
Right. But under Hoffman v. Hunt, Your Honor, and I think you've acknowledged that's binding law.
It's binding law
until
about, it's binding law about what that section means. I agree 100%. I agree 100% that if this case arose under the same statute as that case, the same particular statute as that case, it would be 100% binding on us. But this case doesn't. And I mean this genuinely. I think that's a really hard question, and I'm trying to figure out what the right answer to that question is, and I'm asking, other than just asserting that we're absolutely bound by it, which I do not buy because it's a different statute. I don't think we're literally 100% bound by it.
Your Honor, as I read Hunt v. Hoffman and statutory construction, consistent language in the same statute, I think that's where you end up until you get a
Well,
Supreme.
that
Yes.
certainly has, that's guidance, appropriate guidance that we follow when we're, one opinion is interpreting language, right? And the same language is used elsewhere, similar language. It seemed to me that Sverdrup, it acknowledges that may and must are different, but the reasoning, like the reason for the decision seemed entirely based on the policy and legislative history underlying the domestic enforcement statute, right? The court was saying, there's all these other ways you can enforce arbitration awards domestically that don't have time limits, so like it makes no sense to have a time limit, so we're going to ignore the time limit that Congress wrote. It seems to me that reasoning may not apply here because we're talking about a 3-year time limit that has a different legislative history, right? That the convention came later, that part of the FAA came later. And those policy reasons don't apply here because you have laws like North Carolina's where you can summarily enforce a judgment on an arbitration award from a foreign country. So I was having trouble applying the reasoning of Sverdrup to this statute. But what's your argument for why we should do that?
I'd go back to what Sverdrup said, which is it would be futile, it would be pointless to have this whole process. The whole point of the FAA and the whole point of the arbitration process, enforcement of awards, is it's faster, quicker, cheaper, easier, you get it done.
Well, that made some, charitably, maybe that made some sense in Sverdrup, that it was a 1-year statute of limitations, it's very short, and the only way to enforce arbitral awards domestically was to file a suit at law, right? A suit on a contract, which is going to take longer and all of this, and that seemed to bother the court. But here we have a 3-year statute of limitations, and we have ways to enforce arbitral awards or judgments on them very quickly through state law, like we have with the North Carolina money judgment statute. And so those reasons didn't seem to apply here if we're in a hypothetical world where this is how we interpret statutes.
But if you look at the legislative history on the New York Convention, Chapter 2 of the FAA, it talks about why there is a 3-year, because of the process of what it takes to first try to enforce it in that jurisdiction.
Right, because they're
and then
thinking you're going to enforce it at home
Right.
and then try to take that internationally.
And translate
Very
it.
different than Section 9, isn't it?
It is different, and that's why the statute of limitations is longer, Your Honor. Yeah. And so I thought that was the point you're making, is why couldn't you do it quicker? Well, they recognize that when you're bringing over a foreign arbitration award, it's going to take longer to get here when you first try to enforce there and then have to come here and translate.
Right,
Yeah.
right. And I guess from my point of view, if we're going to follow sort of the reasoning of Sverdrup, I mean, that's the reasoning. It's policy-based, and it doesn't seem to apply one-to-one in our context, even though the words are similar. It seems like you maybe agree with that, but you think we're still bound by it.
Yes, I think you're directed by it, whether you're bound by it, since it is a different, it's 207 versus Chapter 9 or Section 9 of Chapter 1. Yes, it's different, but I think that reasoning does apply here.
Okay, how about this question?
Yes,
Has
Your
any
Honor.
circuit, I understand that courts have agreed with Sverdrup about the statutory provision that Sverdrup construed. Has any circuit held that Section 207's time limit is permissive? Or would we be the first circuit to hold that Section 207's time limit is permissive?
I think you'd be the first, because you got.
So we
the
should
walk
follow a
through.
decision that, just to walk through, we should follow a decision that employs interpretive methodologies that no longer are employed, that is itself the subject of an already existing circuit split to create a new circuit split about a different statutory provision. That's the ask.
Well, the circuit split, so the 6th and the 8th, Your Honor.
No, about this statutory
okay.
provision. We'd be creating a brand-new circuit split about this provision.
Yeah, you create a circuit, right now, there is no circuit split. There's
So,
only-
right, there isn't
right.
one, and we'd
Yeah.
create one that doesn't currently exist.
Right, there's the Second Circuit in sea transport, and
What happens when circuit splits get created with a fair amount of frequency?
they go up.
And what do you think would be the outcome of this case under current interpretive methods?
Won't comment, Joe. Well, I think I know where you're going, Your Honor.
So we should create a new circuit split that might result in us getting reversed?
I don't think you'd be reversed, and I don't think it's creating a circuit split. Or you have two circuits with a split, and what I've seen, Your Honor, is it's when you get 3 or 4 or 5 circuits going different directions, going to the Supreme Court. I haven't seen many.
Can I
and
ask you,
yes,
on the fundamental question about the may,
yeah.
I really genuinely, when I read these cases for the first time, did not understand what the apparent dilemma was about may versus shall. Because the statute says that you may file a petition within 3 years, right?
Correct.
Is anyone ever required to file a petition to confirm an arbitration award?
Under the FAA?
Ever? Like, does anyone have to file a petition? You could just get an arbitration award and the other side pays you and you both go about your lives, right, without going to court.
Right.
So why isn't the obvious reason the may there is to say, if you want to confirm your arbitration award, you have to ask within 3 years, which eliminates any apparent distinction between may and shall. The may is an authorization to do something, and the implicit sort of other side of it is, and if you don't do it within 3 years, you may not do it thereafter. That, to me, seems, just as a matter of plain text, what this statute obviously means.
Well, Your Honor, that was a question I somewhat expected.
Right.
And I think the may means that, just that, you may do it within 1 year under Chapter 1, 3 years under Chapter 2. And you may do it.
Well, no, it turns out you're reading the statute to say you may do it any old time you want.
No, I was going to, Your Honor,
Okay.
what I was going to say is may, and anytime if you do the Chapter 1 domestic under may, you get 1 year. Under Chapter 2, you get 3. Beyond that, what you have, and you may, and nobody has a defense to it. The loser of the arbitration award can't complain. They don't have the defense. After that, I'd suggest that after that, they do have, if you didn't take advantage of the 3 years, you have a laches or a estoppel argument if they didn't pursue it.
Let's go back to your North Carolina dilemma for a minute.
Yes, Your Honor.
I'm not sure this is correct, so I'm just asking.
Yeah.
There is this old adage that an appellate court can affirm a lower court's judgment for any ground found in the record. Was the North Carolina statute also argued before Judge Eagles?
Yes, it was, Your Honor.
So both statutes were argued.
Yeah, the North Carolina Foreign Judgment Recognition Act.
Now, I don't know, and what I don't know is this part. Certainly, if there are facts in the record, the court could find facts to support the outcome the court came to in any way it wanted to. As to a legal principle, I'm not sure, but assume we can. Does that solve your problem, or does a remand solve your problem?
I think it does solve the problem, Your Honor. It was before the court, and Judge Eagles determined that under the foreign, that, as Judge Rushing pointed out, the Court of Rotterdam's award attached the arbitral award. And so it is a court judgment enforcing an arbitral award, and it is entitled to enforcement under North
The only
Carolina.
reason I'm pursuing that
Yeah.
is Judge Hyten's question about, do you really want to take a chance in the Supreme Court on this May issue? And I was trying to figure out a
Right.
way that might avoid that.
Right. Do I want to take a chance on that issue? No, I do not want to take a chance on that issue.
Is there any reason for us, if we agree with your, hypothetically, if we agree with your reading of the North Carolina law and how it applies here, is a remand necessary for anything? I'm legitimately not sure. Do we need to send it back to Judge Eagles for anything to enter a judgment on the North Carolina law, or to clean that up in some way, or to make any additional findings? Or could we, could we just conclude that as a legal matter, the North Carolina law is sufficient to support the judgment that she entered and leave it at that?
Your Honor, I think it'd be remand with instructions to enter an order with regard to, if that's where this court was going, on the North Carolina Act.
Okay, but there's no sort of further proceedings that need to happen?
No, Your Honor, this is before the court as all on matters of law. There's no additional findings of fact.
Let me sort of add similar. Do you believe that the district court has already resolved the North Carolina question?
Yes, Your Honor.
You do? Okay.
I do.
And you believe she did that when? I know the district court denied a motion to dismiss the North Carolina request to confirm. And I know, as Judge Rushing points out, the district court's order says they haven't identified any grounds to not confirm under the FAA. But I don't think that order says that about the North Carolina law. And I don't think the judgment the district court entered mentions the North Carolina law. So where do you think the district court resolved the North Carolina confirmation question?
In her April 29th.
That's the denial of the motion to dismiss?
And then a second one on August 8th, but not in the judgment on August 14th, Your Honor.
The August 8th, that's the opinion that we've been quoting from during, where she talks about, the district court talks about fair drop. Is that, I just want,
No, the April 29th is fair drop. Then they filed an amended motion to dismiss when I moved to confirm the awards.
Okay.
And there, they changed gears and they asked the court to suspend under the Eurocard decision, said suspended, subject to proceedings on the merits proceedings.
Thank you.
But one of the point that I think we've gone by, which is the binding part of it, Judge Floyd, you're right. The NAI, it says in paragraph 46 that awards are enforceable on the day, they're binding enforceable on the day they were made. Provision 35, section 35 says that they are immediately enforceable. And then provision 36 says that those rules apply to both summary and merits arbitral proceedings. So that's how you get there. Just on the first question of the binding, it doesn't seem like the court has many questions about that. But there's no doubt that it is binding. That's all confirmed by the Court of Rotterdam that says this is binding today. So unless the court has other questions for me.
Yeah, thank you, counsel. We'll hear from Mr. Newell on rebuttal.
Thank you, Your Honor. Just to step back into that last point about Article 46 and binding, referring, and here it refers to immediate enforceability in the Netherlands. Whereas for our purposes, the New York Convention is going to require some additional steps. That binding, just because it's enforceable, does not also automatically create a binding nature for the purposes of the New York Convention, which those steps are laid out to create a binding award, which we've already discussed. So we would say that Article 46 does not cover specifically what we're talking about here. Going back to when we were talking about these circuit splits, or just to solve, putting a button on that, as you already referenced, I believe it's Second Circuit, First Circuit, Ninth Circuit, all have made the determination that sea transport is what creates the rule for Chapter 2, which is that issue here. I do think the plain meaning is the best reading of that statute within 3 years, and the continued dispute over may, shall, must, as discussed in the court, just continues to create a system of more confusion, whereas we have the opportunity to establish a streamlined version of 3 years means 3 years.
Well, we actually don't have the ability to do that, because if we agree with you, in contrast, will be saying that almost identically worded provisions of the same statute mean different things, because we don't have the authority to overrule Sverdrup's construction of the statute at issue before the court. So then we'd be in a world in which may sometimes means must and sometimes doesn't mean may.
I believe.
So not just, sorry, I'll state it even more, that in the world of confirming arbitration agreements, may sometimes means must and sometimes doesn't mean must. I mean, that seems like it would create confusion too.
Yes, Your Honor, but the greater confusion would be 3 years or 4 years or 5 years or some indefinite amount of years when it was clear that the intent was for 3 years. I believe if you're erring on the side of what establishes a more clear boundary, the temporal boundary of 3 years is much more clear than just the word may or the word must or the word shall, or it can go on and on. So, let's see. As I said, the legislative intent also appeared to be clear here. We'll make sure I respond to those points. Also, with that 3-year statute, which was already referenced, it provides more time, obviously, than a 1-year statute. And we also know the mechanism for if you're going to go outside the bounds of that 3-year statute, you have the ability to still file and come back to that at a later date. So it's not as if that 3-year statute, there's no process that the appellees could have undertook. They just decided not to go that route as outlined in C transport. So those things were available to them. They didn't take place. Likewise, when we speak about binding, which was our first argument, there were avenues to create a binding award that just were not sought. The provisional relief can be requested from unilaterally, essentially, whereas when you want to get a decision on the merits, it requires unanimous consent, which would have been the easiest way for them to get that binding award. That didn't take place either. So there were mechanisms in place to meet the 3-year statute to also get a binding award, but neither one of those things took place. So as a result, the binding argument would still hold, the 3-year statute of limitations would still hold. Not to mention, this is not 3 years and 1 day, this is 260 days past the 3-year statute of limitations. And clearly the appellees were aware of the statute of limitations based on the arguments that they've made to try to slide in a tolling argument because they are aware that this statute exists. So, last, going back to the NC Act on the money judgment, we would continue to argue that the North Carolina requires a judgment that grants or denies a recovery of a sum of money. I recognize the court's questions about the arbitration award, but I think it's quite clear that it contemplates arbitration awards and says that it does not cover arbitration awards. So we would say it's absent a judgment of a money order, it still does not meet those requirements. All right, unless the court has any further questions.
Thank you, counsel.
All right, thank you.
We appreciate both of your arguments. We'll come down and greet counsel and then proceed with our next case. Mr. Clark, we'll hear from you when you're ready.
Morning, may it please the court. My name is Andrew Clark, and I'm representing Terrence Reeves, who's the appellant. Mr. Reeves is a plaintiff in a case that was dismissed in district court. We appealed the case on, one, for the dismissal at the motion to dismiss phase of the claim of discrimination. We also appealed the case on the summary judgment ruling of the district court on our claim of hostile work environment and also retaliation. Mr. Reeves was working prior to joining this division. Mr. Reeves had 15 years in the federal government, never got a derogatory remark on any of his performance evaluations. Not 3 months after he joins this division is he called in for performance issues. And these performance issues are suspicious, and we believe that because they were pretextual. The performance issues are suspicious because of the fact that we complained that the first action from the defendants occurred in August, when there was an issue with the supervisor talking about an Excel spreadsheet and that the civil Liberties division, all they do is just put forth spreadsheets and they don't do a good job. That was the first issue. Now that is a month after Mr. Reeves starts. So before Mr. Reeves starts, there are already issues with this division, according to these division chiefs. So then 2 months after that, because he says, please don't talk about my employees, 2 months after that, they now say that there's an issue with Mr. Reeves' performance, and they cite to missed deadlines, communication with his employees, and then they have a Halloween party. Halloween party, no one from his division was invited, although they were all
Except
minorities.
the plaintiff himself, right?
Except the plaintiff himself, correct?
Seems like so I wouldn't describe it as conventionally speaking evidence of race discrimination against the plaintiff based on a protected characteristic, evidence that the plaintiff was included in an off-site work function.
I understand your position, Your Honor.
So I mean, they invited me, but they should have invited other people as evidence that they engaged in discrimination against me.
Correct, because the Privacy and Civil Liberties Union, there were no minorities from that division except for.
I'm just saying, I'm going through the chain of inferences we're being asked to follow here, and I do think, like, for example, that there are off-site work events, and most people are included, but some people are excluded, is the kind of thing that could be evidence of discriminatory intent. It just seems like the inference is severely undercut when the plaintiff himself was invited to the event in question.
Yes, except for the explanation provided that members of the Civil Liberties Division would not have wanted to see white people dressed in drag. That was a statement that was made, which is a racial undertone saying, thank you, Your Honor. And even after, and remember, we're dealing with a pandemic during the course of this as well. So now we fast forward to February of 2020. Mr. Reeves was wearing sneakers to commute into the office. When he got into the office, he would change his shoes. Now they have an issue with the fact that he's wearing shoes coming into the office. They set forth, after this February 2020 meeting, set forth a whole new policy about sneakers based on the fact that Mr. Reeves was coming into work wearing sneakers. On February 9th, that was February 7th, on February 9th, 2020, there was a contractor that left. His division chief, Gondek, said that it was because of him. because of Mr. Reeves. Mr. Reeves disputed that, wanted more evidence about the fact that he thought that he was just leaving just for another opportunity. Mr. Gondek then balls up his fists and slams the table at that, or balls up his fist, slams the table, happens later. Then we go to May 29th of 2020. That's when we have the midpoint review. The midpoint review doesn't end up happening because Gondek and Cicchetti are in this meeting, although they don't attend, and they admit that they don't attend other meetings with other heads of chief, but Mr. Reeves felt like this was done and was disparately done because of the discrimination that he experienced before, because of the complaints that he made before. So he believed that that is why they changed their policy, and both of these chiefs were now in the office. They didn't end up having the midpoint review. Mr. Reeves then sends an email about the disparate treatment, and that's that's an informal complaint that he makes. In July of 28, 2020, he then makes another complaint about disparate treatment and also about the aggression especially from his chief head, Cicchetti. On October 28th, he gets a review at this point, and mind you, everyone is working remotely for about a 3-month period during the pandemic. They come back, I believe it was around the August or September time period, and now he's getting a review saying that he's not meeting any of his performance metrics, which then in January leads to him being terminated in the midst of him getting ready to transfer to a whole nother division.
Let me focus you, if I could, on your complaint, on the dismissal. I read the complaint to say, you did say, subject to unlawful conduct and adverse actions because of his race. And I assume that you included 4 or 5 things, including some of the things you've talked about today, as evidence of either hostile environment, discrimination, whatever else you're claiming.
Yes, Your Honor.
Anything else included in there that would go to, in your complaint, that would permit it to survive a motion to dismiss?
Yes, Your Honor. We do talk about another division leader who was a white female who was in the same position, in the same grade under Mr. Cicchetti as well, that did have performance issues, but was not graded the same way that Mr. Reeves was graded.
But those things were pled.
Yes, Your Honor. Yes, Your Honor.
So yeah, tying off of that, could I ask you as succinctly as you can, tell me what allegations in the complaint do you think support an inference? This is on count 1, the discrimination count. What are you think the best allegations in this complaint that support an inference of discrimination because of race?
Yes, Your Honor. The best, I would say the best one is when we're looking at the wearing the sneakers in the office in February.
Paragraph, please. What paragraph of the complaint are we talking about?
This was, I'm sorry, Your Honor, I do have my appendix on my iPad because it's over 1,000 pages.
So the allegations about the sneakers is the place that you think is the best allegations, again, that are not simply consistent with discrimination based on race, but are under Twombly and Iqbal sufficient to move the needle to say that it was because of race?
Well, I wouldn't say that individually, but.
Okay, I'm asking, because, I mean, the district court said you did not adequately allege there was discrimination because of race, and you're asking us to reverse that. So I'm asking, what provisions of the complaint do you think provide the strongest inference of discrimination because of race?
Yes, if you look at the totality of.
That's not how we do Twombly and Iqbal. You need to tell me what language in the complaint you think does this.
Yes, when we talk about first, 1 month into him starting his position, that there are complaints about the minority members of his division. He tells them to stop talking about his division.
Okay.
That's the first, that's just 1 month in.
Him telling his supervisors not to talk about his subordinates is evidence of discrimination because of race?
Because of race, because of the makeup of his division.
Because he told them to not talk about his division? I mean, that might be evidence of retaliation conceivably, but I don't see how your client's own statements are evidence of discrimination because of race.
No,
How about, did you allege in the complaint that he said, that he warned him that if he filed a complaint, he would fire him? And that action had just happened to a person of the African race?
Yes, and that's the first meeting that he has
Did you
with
put
them.
that in your complaint?
Yes, that was. And that's the first meeting that he has with them.
Isn't that consistent with the district court's reading of your complaint, that you specifically tied the adverse employment actions to retaliation, but not to race discrimination, right? There's a hostile work environment claim, I understand.
Yes.
That's based on race, but the district court read the complaint reasonably, I think, to understand that the termination and the negative performance review, which are the only two adverse employment actions, that you were alleging those were because of retaliation. So where in the complaint do you allege that those were because of race?
And I understand the court's question, and the complaint doesn't specifically allege that the adverse employment action is the race discrimination, but rather the actions prior to him being fired, him getting a derogatory performance review, that those are pretextual to the fact that he was discriminated against by having a different standard for what he has to wear to work, a different standard for how he has to perform
But to
on
make a
his
case
job.
of race discrimination, you first have to give us a reason to think that the adverse actions happened because of race, right? That has to be plausible.
Yes,
Apart from whether, well, they have a reason, and the reason is he's received bad performance reviews from day one, and then you say, well, it's pretextual, right? That's kind of a secondary question. We have to initially just be able to read the complaint and see that there's a plausible claim that he was fired because of his race. And where's that?
Understood, Your Honor. And I would admit to the court that there's nothing specific that says that he was fired because of his race.
Well, you can have the same facts support a different type of, a different issue. For example, hostile environment discrimination. But did you specify that those same acts applied would support a claim for hostile environment or support a claim for discrimination because of race? I mean, you could use the same facts, but you gotta sort them out so the district judge, as Judge Rushing pointed out, he looked like you were catering your pleadings to just one thing.
Understood. And that section dealing with discrimination, there is a reference to the facts, and I do see the court's issue with referencing all of the facts without putting in specific facts is what the court took issue with, but it was all incorporated and should have all been included in the court's analysis of whether or not there was race discrimination. And Your Honor, when we're dealing about severe and pervasive, that was what was, I think, the district court's issue with the case is that it wasn't severe and pervasive enough. They were making, the court was, the defendants were making arguments and the court was making rulings about the fact that they believed that the actions of Mr. Cicchetti were just either they weren't close enough in time or they were more so just statements being made. When you look at the performance review that Mr. Reeves received at the end of his employment, and the fact that within months of him starting his employment, that they had an issue with the division's performance, that gives everything that happens in between, that gives the context that this was not a neutral-based review. From the beginning, they had it out for Mr. Reeves. They wanted him gone. Once he did not play by their rules in August, when he didn't allow them to speak poorly about his chief members, from then on, they documented everything that they believed was derogatory performance reviews from not only him, but also his team members, Your Honor. If there are no other questions, I believe that my time is up.
Thank you.
Thank you.
We'll hear from the government's counsel.
May it please the court, Assistant U.S. Attorney Peter Baumhart on behalf of the defendants. This is a case, like many others this court has considered, where the plaintiff's view of his own performance differs significantly from the perspective of his supervisors. The record in this case amply bears out that plaintiff's performance did not live up to his employer's expectations almost from the beginning of his tenure at NGA and never meaningfully improved. And while plaintiff insists that it must have been discrimination or retaliation at work rather than his supervisor's perceptions of his shortcomings, there is simply no evidence that creates a genuine dispute of material fact on that point. Plaintiff also failed to plausibly plead that racial discrimination was behind the few actionable adverse personnel actions in the complaint. This court should affirm the judgment.
Okay, let's take you to the retaliation claim.
Okay.
So I read the following sentence in the district court's opinion. This is JA 1028. There is no evidence of any recognized basis on which pretext can be reasonably inferred for purposes of his firing. What about the fact that the plaintiff testified or gave some sort of statement that on one of my first days of work, someone says, if you ever file an EEO complaint, I will fire you. He filed an EEO complaint and he was fired. I don't understand why that is not plausible evidence that he was fired because he did the thing that his supervisor said, if you do, you will be fired.
So, Your Honor, first I would point out that the comment was allegedly made by Mr. Caccetti, who is not the person who decided to remove.
Well, hold on. Let's get back to allegedly. So on the summary, you agree that the plaintiff testified the comment was made, right?
Yes.
So for purposes of summary judgment, it wasn't allegedly made. It was made.
Okay.
Please continue.
Fair enough, Judge Heitens. Yes, assuming that the comment was made as the plaintiff testified to, it was made by Mr. Caccetti. Mr. Caccetti did not make the decision to remove plaintiff from federal service. That decision was made by Kimberly Thompson, the head of human development, after the proposal to remove plaintiff had been considered by two separate levels of independent decision makers, which was employee relations and then the performance evaluation.
But that's an argument that it breaks the causal chain because there's two ways to interpret the statement, and since it's summary judgment, we interpret it in the way that's favorable to him, not the way that's favorable to you. The way that's favorable to you would be, if I have anything to say about it, you'll be fired. Or if I have anything to do with it, you'll be fired. But what it could also mean is, oh, sorry, I've been working here for a very long time, me, your supervisor. I know what happens to people who file EEO complaints. So I'm just going to tell you as a friend, if you do this, you're going to get fired because we fire people who file complaints like this.
Your Honor, I think that is potentially a too favorable way of reading that testimony for the plaintiff. I think there's a lot of inferences that would have to be follow along.
It's very rare that you get a retaliation claim that says crystal as a supervisor says, and again, I understand your position is it almost certainly that it wasn't said, but on summary judgment, we have to assume it was said. We almost never get employment discrimination claims where people are as unbelievably stupid as to say, if you do this, I will fire you, and then fire people, right? Because that's brazenly illegal.
Right, I think it is an unusual part of the case in that respect. But I would, again, point the court to
But it's not implausible. I mean, you're not asking us to discount the statement on the grounds that it's so implausible it doesn't warrant an assumption of truth under Twombly. Like Twombly says, like if the plaintiff talks about his experience with time travel or Little Green Men, you don't have to accord an assumption of truth to something that breaks reality as we understand it. It may be unusual, it may be surprising, it may be really ill-advised that your supervisor would say something like this to you, but it's not so implausible we can pretend it's not true for purposes of deciding this issue, right?
I would agree with that. Your Honor.
Okay, so we have to assume it was actually said.
Yes.
Okay.
Yep, I agree with that.
And what's
I-
your best authority for the proposition that a supervisor told me if I did something, I'd be fired, and then I was fired is not enough to create a genuine dispute of material fact about whether that is in fact what happened?
So I just want to make sure I answer your question accurately.
No, I understand.
So I'm not saying there is a dispute of material, well, okay, so,
Sorry, the fact that the statement was made, the fact that he did the thing, it was basically an if-then statement. If X, then Y.
Right.
There's an if-then statement. And we know that X happened, and we know that temporally after X, Y also happened, and those are the three facts that we have. Why is that not enough to create a genuine dispute of material fact that the reason that Y happened was because of X? And the evidence that that happened, in addition to the fact of the temporal sequence, is that someone literally said, if X, then Y, and then X, and then Y.
so I would point the court to three different cases.
Okay.
First, for the notion that a statement that's made prior to, over a year prior to the adverse action at issue, doesn't bear on the pretext part of it, is Lang versus Federal Express Corp. I would point the court for the proposition that a decision by, or a statement by the non-decision maker is not evidence of retaliatory animus, I think it's Walton versus Harker. And for the point that it matters on this point that it went through multiple levels of independent decision makers is Massaro versus Fairfax County. So those are the three cases I would point you to.
Did he start receiving the negative performance reviews before or after he filed an EEOC complaint?
Your Honor, he started receiving, there's documented performance issues by Mr. Gondek and Mr. Caccetti in the record before he engaged in protected
It
activity.
was in like the first couple months, right?
Yes, Your Honor. I mean, so in some of Mr. Gondek's and Mr. Caccetti's documentation, there are issues arising as early as late August. We have emails between Mr. Gondek and I believe LaToya Allen, who I think was in human development, or possibly employee relations in late September into October. And the first protected activity the plaintiff engages in that Mr. Gondek and Mr. Caccetti had any knowledge of was in June 2020 when he makes the call to the anti-harassment division. So, yes, sticking with...
So those three cases you just cited, is any one of those in your brief?
Massaro is, and Walton and Lang, I've found as I've been preparing.
Did you
for
tell the
argument.
other side that you were going to spring these cases on them at oral argument?
We cited Lang, I believe, in the district court. As our
So that's a
summary judgment
no?
briefing.
In the sense that you didn't file a 28J letter or anything like that?
No, Your Honor, we didn't file a 28J letter.
Okay. I guess these cases about temporal proximity strike me as fundamentally different, and let me say why, and let me give you a chance to explain why I'm wrong. Those are cases that basically, the temporal proximity is the time between when you file the EEO charge. Okay, so let's take the easiest case. The easiest case would be I file an EEO charge, and literally 30 seconds after EEOC notifies my employer, my boss picks up the phone and says, Toby, you're fired, right? In that case, the temporal proximity provides extremely strong evidence, right? And I get the point that if that's all the evidence we have is the delay between EEO charge and adverse action, that the longer it gets, the inference gets weaker and weaker and weaker and weaker and weaker and weaker and weaker. That makes total sense, right? Because the mere fact that because X preceded Y does not prove that X caused Y. And so I agree, and that the bigger the gap between X and Y gets, the weaker the inference that that's Y gets. But in virtually all of the cases that say that I have seen, if not all of them, there is not a point at which someone who is above the plaintiff in the org chart literally said to the plaintiff, if you do X, then Y. Do you know any case that has had that fact pattern? Of the cases that say the longer that happens, it undercuts the inference of pretext. I wasn't able to find any where there was literally, allegedly, a statement by a supervisor that said, if you do this, we'll fire you.
So I'm not recalling a specific case that says like.
Or that involves that, not even that makes that point, but that involves that fact pattern. I think all the cases I've seen about temporal proximity are just the plaintiff says, I filed a complaint and 5 days later I was fired. Right, but not the allegation is I was told if I filed a complaint I'd be fired.
Right, and I take your point. And I'm trying to remember, I don't remember off the top of my head whether the comment in Lang was made by a supervisor.
Okay.
But the court did in Lang note that it mattered that it was made before the plaintiff ever engaged in protected activity and long before the challenged employment action occurred. And so I mean, that's the closest I can give you.
Just for my edification, honestly, is telling an employee, if you file a complaint, I will fire you, is that itself an adverse employment action? Or is that itself something that violates Title VII? I mean, the reason I imagine that you would tell someone, if you file a complaint, I will fire you, is to deter them from filing a complaint. And if it works, if the person never actually files a complaint, has that itself been a Title VII violation?
I'm not aware of any case that's addressed that.
Because it seems really troubling that the way you could get out of EEO complaints is just tell people, by the way, don't ever do that. And if the threat is really effective, you won't have violated Title VII.
You're right. I know, I understand what you're saying, and I know the Burlington Northern Standard is couched in terms of, would dissuade a reasonable employee from making.
Feels like it might dissuade a reasonable employee.
What do we do with if it's evidence at all, of the internal investigation that showed that some substantial percentage of the employees believed or knew supervisors conducted retaliatory conduct? What do we do with that evidence, or if it is evidence?
I'm sorry, are you referring to the anti-harassment?
There was an internal investigation about where several of the employees were questioned about whether there was retaliatory conduct or not, and they answered the question, yes, there was. A culture of it.
So if Your Honor is referring to the anti-harassment investigation, I believe that was focused on Mr. Reeves' allegations of a hostile work environment rather than retaliation. And the employees did make statements to the investigator that there was an environment of, probably too much joking and maybe some disrespectful comments, but the investigator ultimately, I might add, several of the employees said that plaintiff himself was part of the problem and was treating his employees poorly. But the investigator ultimately concluded that plaintiff's allegations of a hostile work environment were not substantiated, and that the supervisor's conduct, Mr. Caccetti, Mr. Gondik, may have violated, I think, particular DOD and or NGA rules about like a respectful workplace.
Well, let's forget about his conclusion. What do we do about the statements that the individual employers made to him that there was a hostile environment?
Well, so Your Honor, I mean, to the extent that there's a hostile environment, that the employees make claims of certain activities by the Mr. Caccetti, Mr. Gondik, that there's no evidence that plaintiff himself either experienced or knew of, then those aren't considered for purposes of his hostile work environment claim, and that's, off the top of my head, this court's decision in Perkins.
So your position is not relevant to his claim?
Yeah, unless he himself testified that he experienced it or knew about it, then it's not relevant for his claim.
So can I ask you about the AR-15 incident, which I regard as the sort of most probably troubling for the hostile work environment claim? Can you just help me what the top line for this isn't an objectively hostile work environment because the government's view is what? Like, let's assume that so you have this issue about he tells two slightly different stories. Let's assume for the sake of argument that I do not think that there's an irreconcilable conflict between the two version of events he gives, and thus we have to credit the one that is most favorable to him. If that's true, what's your argument for why that's not a hostile work environment?
So I will say that plaintiff himself, that this is not about, there's two parts of that particular encounter that
Sure.
I think are salient. Specifically respecting the picture of the AR-15, plaintiff himself testified that he did not think that showing the picture was racially motivated. It instead occurred in the context of Mr. Caccetti having had a conversation with several other contractors in the office earlier in the day, of which plaintiff was aware about various firearms they owned.
But then he does say that when the person then pivots and says, hey, by the way, sort of apropos of nothing, while we're looking at this gun, would you like me to tell you why I bought it? And then he tells a story that's extremely racially inflected.
So on that part, again, a couple points. First, Mr. Reeves himself drew the distinction between whether he thought the showing of the picture was racially motivated and whether the story that followed was racially motivated. Although, again, as you acknowledge, he was not entirely clear on what Mr. Caccetti said, one of which was race neutral and one of which was not. And so I think we credit Mr. Reeves' testimony that the showing of the picture wasn't racially motivated. because that's how Mr. Caccetti testified as well, and so there is no dispute of any kind.
That's a little weird to say, though, because the defendant, including the government, when it's an defendant, employment discrimination claims, which is to say, just because the plaintiff believes that something was racially motivated, we don't give it a presumption of truth, right? There are cases that sort of say, like, a plaintiff's unadorned statement, I believe I was fired based on race, gets basically no weight for Twombly-Iqbal purposes. It gets basically no weight for summary judgment purposes, because a plaintiff's unadorned, I believe something illegal happened to me, is just a restatement of the fact that the plaintiff believes he has a cause of action against the defendant. It adds no additional facts. So why wouldn't the inverse be true too, which is that, I mean, I understand that for hostile work environment, he has to show that he both subjectively experienced a hostile work environment and that it was so help me understand that.
So, Your Honor, I think it's actually the other side of the same coin,
Okay.
which is that there has to be evidence that what happened was racially motivated. The plaintiff's speculation won't do it. And here, my point is just that there is no evidence, even from plaintiff, even his own speculation, as to was a racial motivation for.
Okay, so what about the racially inflected story that talks about, that we're doing right after we've shown someone a picture of a firearm in the workplace?
So I want to also just slightly quibble with your description of how that story was described, which is that Mr. Reeves did not testify that Mr. Caccetti told him he bought the AR-15 specifically for the purpose of keeping people out of his yard. What Mr. Reeves testified to was that he said something to the effect of, now that I have this, I won't have to worry about someone coming into my yard.
Someone like the people who did something to me before, which just so happens to have been told in a way that's heavily racially inflected.
So that part comes, again, after the part about I won't have trouble with people coming into my yard. And so I will say, again, I acknowledge that we have to take the plaintiff's version of what Mr. Caccetti said was true, setting us to one side, the question of whether giving two different versions of that, one race neutral, one not, is sufficient to survive summary judgment.
You're not conceding anything by accepting the premises of my question.
No. So my point is that comment, while offensive, certainly not an appropriate thing to say, is well within the sort of comments that this court has repeatedly found do not rise to the level of severe or pervasive. And I can give examples of those if you would like.
There's some pretty bad things that we've said aren't severe and pervasive.
Yes. I mean, there's Robinson that says, someone says, come over to the white side. There is McIver, where someone said, on plaintiff's team, we were doing just fine without black people before she came.
So then how do you distinguish? But on the other hand, we do have cases that also say, like, one thing, if sufficiently bad, can all by itself essentially create a hostile work environment, right? Mm-hmm. This usually involves the use of a particular word. What's your best argument for why this is not that one thing? This is the one thing kind of case?
Your Honor, so obviously there's a spectrum of things you can say in the workplace. I think the sort of cases where that issue has come up, the single instance, are like Boyer-Lieberto, where, a supervisor used a slur multiple times that I won't repeat. But my best authority is all the cases we cited in our brief that say that this type of comment that the plaintiff alleges, while inappropriate, again, not alleges, testified to, while not appropriate, is not.
Okay, so what about?
Can I just clarify what we're talking about? Because there
talking,
was one of accusation about who it was in the yard, but I don't think that's what we're talking about, right? Is this the story that when he was a young man in New York, he was jumped by some people and then he shared the race of the people with plaintiff?
Yes, that's what I understand.
This is what we're talking about. There's no slur. There's
right.
nothing about the workplace.
Right.
This is like in my past, now I don't trust people because I was once jumped by some kids.
Right.
Okay, I just want to make sure I understand we're all talking about the same story.
We are, yes.
Okay, so can I take you to the Halloween party?
Sure.
Positing the point I made with your friend on the other side of it's a little strange because the plaintiff alleges that he was invited to the very party. But what about the comment about the plaintiff's the people the plaintiff supervises, which is obviously racially inflected? Yeah.
So, again, we have to take that at face value given the posture the case is in. It's a little difficult to know what to make of that comment. I think it's ambiguous at best, particularly considering, as you noted, Judge Heitens, it was in the context of including plaintiff in the party. There's a lot of reasons why. Mr. Caccetti was plaintiff's second-line supervisor, so he would have been even farther outside of, the plaintiff's employees in terms of reporting chain. And as plaintiff has made clear, he had a new team. And so Mr. Caccetti.
So the obvious alternative explanation is that a fourth-level supervisor doesn't necessarily want entry-level employees at a party that's going to have a bunch of supervisors at it?
Could be, and also Mr. Reeves was new, and perhaps Mr. Caccetti was just trying to include him and get to know him, given that they were going to be working on the leadership team together. But again, in all of these sort of, one-off points about that the plaintiff raises about, how we can infer that this is racially discriminatory are complicated by the fact that they all pertain to Mr. Caccetti, and it was Mr. Caccetti who hired the plaintiff, or at least he interviewed plaintiff and recommended that he be hired after the interview, which this court has been clear cuts against any inference of racial discrimination in cases like Tyndall and Proud. And so, I think it's talking about the hostile work environment part of it. It's a totality of the circumstances analysis, and the facts of this case, although some certainly would be troubling, and I take your point, Judge Heitens, are well within the sort of spectrum of cases where this court has held as a matter of law there is no hostile work environment. I have just a few seconds left, so I want to touch briefly on the dismissal of the discrete act race discrimination claim. There were two components to that, which is first that Judge Trenga concluded that the only two actionable events in the complaint were the performance evaluation and the removal, and that plaintiff not only didn't allege that those were racially discriminatory, but expressly alleged that they were retaliatory. And nothing else in the complaint, including paragraph 40, which is what I believe plaintiff points to, changes the fundamental character of those allegations. And under this court's decision, Lucas versus VHC Health, that alone warrants dismissal. And now I'm over my time, so unless the court has further questions, we'll rest in our brief.
Thank you.
Thank you.
Your Honors, I just want to make a few points here. So when you're looking at just the first 5 months of Mr. Reeves' employment there, within 3 weeks, he gets called into his office and told that the previous supervisors who were African-American were fired, and that if he files a complaint, he would be fired too. Then a month later, there's a comment made about the performance of his division, which is mostly African American. Then we have a Halloween party to which those African American employees were not invited. Then we have these comments being made about the about an African American beating up Mr. Caccetti, and that now that he has his AR-15, this won't happen to him anymore. Then we have the comments about the clothing.
Sorry, we do have to obviously take the evidence in the light most favorable to the plaintiff, but I don't recall reading that in the record. Now that he has an AR-15, he doesn't have to worry
I'm sorry.
about people beating him.
I'm making that inference, Your Honor. Yes.
Yeah, let's
Yeah.
keep it to the record.
Yes. And then we have the comments about his clothing, that his pants are sassy. They give him a hot mess citation. These are not just joking comments being made. These are targeted at Mr. Reeves because of his.
Regarding the last couple of things you mentioned, didn't other employees say they received those same citations from like a Post-it stack? They're not targeted at him, they're targeted at everybody there? Everybody was receiving these silly notes?
They were silly. I don't recall it being specifically about their pants being sassy, but there were other silly notes being passed around that were offensive. And when you take those just in the beginning of his employment, you take all of those issues. Clearly, Mr. Caccetti did not want Mr. Reeves to succeed. We then have documented performance issues within the 3 months of his employment, which again, I want to stress to the court that Mr. Caccetti and Mr. Gondak already had an issue with the performance of that division even prior to Mr. Reeves coming on board.
Right, but the criticisms weren't about his division performing poorly, they were about his performance, that he wasn't doing things on time, He wasn't communicating that his work product he was turning in was poor. They were about his performance, not about the division, right?
They were about his performance, but in his duties as supervising, he's delegating these duties to other members of his team. So in essence, they are still talking about the performance of his team and saying that they're not
Didn't all of his
performing.
team members get positive reviews? They all got really good reviews, it looked like.
That is correct, and that's even more evidence. I would argue that's even more evidence about the fact that they're singling out Mr. Reeves, saying that his performance is poor, but yet still the people that he's supervising are excelling. I don't see how the two would make sense. And those are the points that I wanted to make, Your Honor. If you have any more questions, I'll be happy to answer.
Okay, thank
Okay,
you.
Thank you.
We'll come down and greet counsel and proceed with our next case. Dash 4250. Mr. Compton, you can proceed when you're ready.
Thank you, Your Honor, and may it please the court, my name is Nicholas Compton, and I represent the appellant in this case, Talton Hall Jr. In this case, Mr. Hall entered a guilty plea pursuant to a written plea agreement to one count of possession of a firearm in connection with a drug trafficking crime under 18 U.S.C. 924 C1A. His guideline range was determined by the district court to be the mandatory minimum sentence of 60 months, which is the sentencing range dictated by the guidelines. At sentencing, both Mr. Hall and the United States argued for a guideline sentence of 60 months. The district court, sua sponte, imposed a sentence of 84 months, representing a 24-month upward variance. Mr. Hall asserts that in imposing this sentence, the district court committed procedural error in that it failed to consider his non-frivolous sentencing arguments, including the conditions of his pretrial confinement and his attempts while in the jail to rehabilitate by taking some online courses.
I just want to confirm what you just said because it confirmed what I thought. So there is one sentence in your brief that suggests the sentence was substantively unreasonable, but you are not asking us to reverse on the grounds that the sentence is substantively unreasonable.
That is correct, Your Honor, and I as well saw that.
Okay, no problem. I just want to confirm.
Yes, Your Honor, that's correct. As the court is aware, sentences imposed by the district court are reviewed for reasonableness under abuse of discretion standard. In determining procedural reasonableness, this court is to consider whether the district court properly calculated the sentencing guidelines, gave the parties an opportunity to argue for an appropriate sentence, considered the 3553A sentencing factors, and sufficiently explained the sentence. Procedural error includes failing to calculate those sentencing guidelines accurately, treating the guidelines as mandatory, failing to consider the 3553 factors, selecting a sentence that's based on clearly erroneous facts, and for our purposes, we believe here today, failing to adequately explain the chosen sentence.
And just again, to continue to isolate the issue before us, you agree that none of those things before the last one is triggered here?
I would agree with that, Your Honor.
Okay, so
Yes.
the district court calculated the guidelines correctly, the district court did not identify any reason that was illegitimate, and the district court did not, unless to the extent the district court failed to consider one of your client's arguments, the district court did not inadequately explain why it was doing what it was doing, other than possibly not explaining why it was rejected. Right, I mean, I guess I'll just say I'll tell you, to me, that the hard thing about this case is this is an extremely thorough sentencing hearing. We constantly review sentencing hearings where district court judges are way less thorough than this and way less engaged with the defendant's arguments than this, and we affirm many of those sentences. So, I mean, I think on balance, this district court judge did a terrific job, and honestly, an unusually good job at engaging with the defendant's arguments. But your argument is, but we also had some arguments that the court didn't mention, and that, to me, is the sort of central tension in this appeal.
And I agree, Your Honor. I can't stand up.
This was
here
not a
and say-
perfunctory sentencing hearing.
That's correct, Your Honor, and I can't make that argument before the court here today. I believe Judge Groh did explain, again, why she imposes.
Right, like, so
sentences
sometimes you read these and you wonder, like, from a little d, a little p, I'm not saying whether it would violate the Fifth Amendment or the 14th Amendment, but from a due process of what, obviously, we're about to explain to a human being why he's going to lose his liberty for a certain amount of time. That's a big deal, right? And sometimes you read these sentencing transcripts and you come away with, like, I don't even really know why the district court did what it did, and I imagine that from the defendant's perspective, that feels pretty unfair, that I don't know why. I don't know how anyone could have come away from this sentencing hearing not understanding why Judge Groh picked the sentence that she did.
I don't disagree with that, Your Honor, but I do agree that we have an additional, I think, issue here.
Sure.
For a couple of reasons. I believe here we have a different scenario in the sense that the district court, again, on its own, imposed an above-guideline sentence.
But that, I think it doesn't really matter anymore. Once there's, well, I mean, I guess it matters some, but I just think you have this lurking substantive, there's this lurking feel to your argument that this sentence is maybe substantively unreasonable, but you don't want to argue that, and I'm not saying I'm criticizing you for that, because it strikes me as pretty obvious that a substantive reasonableness challenge would not succeed, because Judge Groh basically said, quite rightly, this very easily could have been an attempted homicide prosecution. And once you think of it that way, it's hard to argue that 84 months is substantively unreasonable. But walk me through why, just that we've said that in the procedural context, if you're going to go up, you have to give more reasons than if you're not going to go up.
And I think also that you have to, and I think the court's precedents in this area say that these are non-frivolous arguments. I don't believe the government is necessarily contesting that they are non-frivolous arguments. And if they are non-frivolous arguments, then the court has to address those in the context of.
Is that the law? I think our precedent says the court has to consider them, right?
I think my reading of the court's precedents in Perez-Paz and in the Shields case, which I will note I did not, was not cited. It's a very recent case. I did not cite that in my brief. But it relies on Blue, it relies on Ross, it relies on Lynn, which are cited in the brief. Those cases all say that, yes, the court has to consider it, but the court has to give, there has to be enough on the record for a reviewing court to be able to look at the record and say that the court did consider it.
Right, we have to be able to know that the district court considered all of your non-frivolous arguments. That doesn't mean the court had to specifically address them all and explain why she didn't find them persuasive, but she has to consider them all, and you need to point us to something in the record that shows she didn't consider it, right? What is your evidence she didn't consider these arguments?
Well, I think the evidence, Your Honor, is that she didn't discuss them or engage.
She definitely discussed them. So when it comes to Jimmy Lambert, right, the fact that your client was attacked by another inmate, she named the inmate by name and said, Jimmy Lambert, who is the guy who attacked your client, I don't know how he was roaming around at this jail. I sentenced him. Like, she clearly was aware of that argument, right, and considered it. Counsel, I don't know if it was you, but whoever was representing your client at the time, mentioned the conditions. You know, your client contracted COVID, and counsel was mentioning the conditions at this jail are not great. You know, it's kind of unsanitary. And counsel said, you are very aware, Judge, of the conditions at Eastern Regional Jail, right? Which seems to acknowledge that she was aware of the conditions of confinement. She was aware of what had happened to him. And the argument in the briefs and the argument at oral argument to the judge at sentencing were just, these things happened. There was no, like, therefore, his sentence should be reduced by a certain amount or anything. It was just like, these things happened. And she acknowledged they happened. How can I infer from the fact that she explicitly talked about these factors that she didn't consider them?
Well, Your Honor, our position is that just by making essentially an interjection in my argument that she didn't understand how a previous federal inmate who she had sentenced was just walking around doesn't address or, I believe, imbue that statement with any consideration of how that might apply, then, which is what we were suggesting both in our oral argument and in our sentencing memo, how that might relate to his personal history and
But doesn't
characteristics.
the fact that she acknowledged those arguments were made, and I mean, there wasn't much said about what the implication of it was from counsel, but the fact that she acknowledged those arguments were made shows us she read the briefing, she listened to the arguments at sentencing, she considered it, right? Now, we don't require district courts to then provide a paragraph of explanation of why they're rejecting each argument. We have to understand that they considered it, and we typically look for them to address like the major arguments, which here seem to be that he's kind of outside the norm of this offense.
Well, I believe, and I think the government tries to make that point in their response. I would disagree that there was a central thesis or a central tenet to the argument that that this 924C case wasn't the same as others. That was an argument, and we made the argument as part of our.
It was the lead argument in both the sentencing memorandum and at the hearing, right?
That's what I started off.
This is not a typical 924 case. That was the argument that led off in both of those things.
Yes, that's correct, Your Honor, but I don't believe that transforms it into the central argument. It's what I started with.
And it's also by the way, it's very clear why the district court rejected that argument, right? The district court made very clear, I reject the premise that this is not a typical case under the statute.
Sure, absolutely. Right. And I think that's what we were looking for here with regard to this part of the personal history and characteristics of the defendant. Did she consider this? We don't believe that the one statement that she made did, and if she did consider it, why she was rejecting it.
So we've already talked. So we've talked about the conditions. Can we talk about the anger management issue? Because again, the district court very clearly engages with what the district court very clearly thought is a record that reveals that the defendant has serious anger management problems, because the district court identifies it as a major reason for the district court's sentence. Now, the flip side. The district court does not acknowledge that he had taken this anger management class that's mentioned both in your filings and at the hearing. But the district court is not like unaware of like what is the defendant's anger management capacity, right? The court clearly talked about that too.
I agree, Your Honor. Our position is that because these were non-frivolous arguments that no one seems to dispute.
The non-frivolous, but on the anger management, the non-frivolous is, if you're going to give me a harsher sentence because I have anger management issues, you should then give me credit for the fact that I have done something to try to address them.
Exactly.
Okay.
I believe that goes to, I believe we argued that goes to.
And that was 1 hour, right, that class?
And I'm not suggesting that
1 hour
the court
online.
couldn't consider it and reject it.
Could we find it harmless if she didn't consider it because it's so minuscule?
Well, and I think the Shields case that relies on Blue and that relies on Ross also talks about how the harmless error consideration is not applicable when you have non-frivolous arguments that the court, in our opinion, again, did not consider or did not acknowledge that they considered and rejected, particularly in imposing a sentence above the high end of the guideline.
As Judge Heitens pointed out, she acknowledged that he had this history of poor anger management, along with other things in his history, depression, attempted suicide, and that he would benefit. She said he would likely benefit from a mental health assessment and some intervention. And she put all of that in her sentence and on the record. So why shouldn't we infer, we have a presumption, right, that courts consider everything that's in front of them, and that presumption has to be rebutted. And why shouldn't we infer from those comments that she considered that he had taken a 1-hour course, but that had not been sufficient to deal with his anger management problems, and that he would benefit from further intervention, as she said?
Well, I think this court's precedent talks about how this court should not be required to guess from the record whether the court.
Right, that's why we have a presumption that district courts consider everything in front of them. We don't have to guess. Instead, we look for evidence that they didn't. What's the evidence they didn't do what they were supposed to do?
Yes, Your Honor, I see that my time is expired.
You can answer.
I believe that the court's precedent talks about whether or not this court has to guess from what's in the record, whether or not the court actually considered it and rejected it. It's certainly possible that that's what happened, that the judge considered this what she may have thought was a minor 1-hour course and he needs more. But this court, I believe from the record, is left to guess, would she have imposed a higher sentence but for this that he took a 1-hour course? If she didn't consider it, would she have imposed a lower sentence or a guideline sentence that both parties asked for? I think that's the guessing that this court is left to do, because it's not clearly articulated on the record whether or not this is something that she considered or not, or if she did consider and rejected it.
Thank you.
Your Honor.
We'll hear from the government.
May it please the court, Eleanor Herney on behalf of the United States. I'd like to begin by starting with what Judge Heitens identified, that this is a tough case. It was a tough case to prepare to argue for, and it was a tough case to write the brief for, solely because, as you identified, it is a very thorough record. And so we're really looking at a question here of whether, when we look at the totality of the record, is it enough? And I think
Doesn't that make it an easy case? That
Well-
there's lots of evidence and she said lots to support her sentence?
There is, and then once I began researching even deeper and getting into the quandary of consider versus address and patently obvious and where everything falls under the Fourth Circuit's precedent, I believe that in this case, if we look at the totality of the transcript, if we look at the exchange between counsel and the court, and if we look at the arguments that were articulated, the bases for the sentence imposed, and the fact that the district court confirmed that it considered all of the 3553A factors.
What would strike me, that counsel would be almost asking for a bright line test here, that if you have this argument, you check this argument, the district judge has to go here in this box and check that all, line by line. I don't think that's where we are in our jurisprudence on sentencing. I mean, I was a district judge, and it was, it comes at you fast and furious sometimes. This is what this case looks like. She gave a pretty good narrative to me about what she thought about the whole case. It was pretty thorough. But we're not at a bright line rule, are we?
I would agree with that, Judge Floyd, and I think that the court, the Fourth Circuit and the Supreme Court has been clear that we don't mechanically and robotically tick through the 3553A factors, and that we can look at the context, and that we can not only find, consider, or address met through express rejection, acceptance, or consideration of arguments, but we can also look at the context. We can look at the entirety of the transcript.
Okay, in terms of identifying why this is hard, I think we do, but I just want to make sure we can agree on some premises. So you're not arguing, because I don't read your brief as saying, that his rehabilitation or poor conditions arguments are frivolous. You're not arguing that those are legally frivolous arguments, right?
That's correct,
Okay,
Your
because
Honor.
we've said you don't have to explain why you reject frivolous arguments, but those aren't frivolous arguments, right? Second, you say in your brief that Section 3553A does not require courts to consider poor conditions of pretrial detention. That's different from saying that they can't. And you're not arguing that they can't, are you?
Agreed, Your Honor. I am not aware of any prohibition on considering that.
And if a court can consider it, and if a defendant raises the argument that you should consider it, the court has to consider whether to consider it, right? I mean, it could say, I don't think, the district court, unless 3553A mandates it, the district court could say, I hear what you're saying and I'm terribly sorry that that happened to you, we should look into that, but I don't think that's appropriate in deciding how long your criminal sentence could be, right?
I would agree with that, Your Honor.
But the court could also say, actually, I think that is a good argument. I mean, I guess, would it be procedurally unreasonable for a district court to give a lower sentence because of harsh conditions of pretrial confinement?
I would say, Your Honor, based on the status of the law, and specifically looking at United States versus Peterson, which is, I believe, a 2007 case, in which we quoted in our brief, and expressly leaves that question open.
Right.
I don't think it would be procedurally unreasonable for the court to do that.
To do that, okay. And then last but not least, in terms of framing, in terms of harmless error, I will confess that I find it extremely confusing how you could have harmless error in this context, because the idea of harmless error is, the error is you didn't do a good enough job making sure that you considered the defendant's non-frivolous arguments. And we would say it's harmless. Like, it just seems weird that this is the kind of violation that even could be harmless error. Now, I think what you can easily say is, like, if you do a good enough job on balance, which I understand to be the thrust of your argument, you say that's not error, right? It's not, like, perfection is not the goal. The goal is to be adequate to avoid error. But once you conclude it is error, it's very weird to me to say that there is error because the district court, for all we know, was not considering a non-frivolous argument, but it's harmless. I just don't even know how harmless error works in that context. Because the error is the error of not considering it, and I don't know how it can be harmless to consider something that's not frivolous.
And I absolutely understand that perspective, Your Honor, and it's something, as I indicated, it is a tough case, and that's one of the things that I've struggled with. And I am thankful to Mr. Compton for invoking Shields before I had to be the one to invoke it. But I do believe that at least in the case, and I think we can separate out the pretrial conditions of confinement from the anger management / rehabilitation. Because I think in terms of the pretrial conditions of confinement, given how fact-bound that would be, it is a harder argument to say, you know, it would be harmless error.
Do you know if you're in your district? I think we've had an opinion recently. These cases keep coming up, and I'm sure they're very frustrating for district court judges. I'm sure they're very frustrating for litigants on both sides. They're frustrating for us too. I thought we had a published opinion recently that said, you know, there's a really easy solution to this problem, district court judges, which is that before you pronounce the sentence, you look at defense counsel and say, do you believe that you have any arguments that I have not yet addressed? And if they say no, congratulations, any issue now is forfeited under Federal Rule of Criminal Procedure 52B. Are we doing that in this district? And if not, why not? It seems like the easiest solution in the world is to say to defense counsel, is there anything you think I haven't addressed?
Your Honor, this is actually something that defense counsel, appellant's counsel and I did briefly address, just discussing, and it is not. I am familiar with the opinion, and politely, that is above my pay grade.
I understand. I understand.
But it is not something that's become a routine practice.
Okay. Because it really feels like a lot of these cases would just go away if district judges would just say those words. Great. Okay. So what's your best argument? So Judge Rushing, candidly, I would say, and I'm sure you're being even nicer about it, but I don't have to because I'm not studying at the lectern. I think our opinions in this area are all over the map, and many of them are inconsistent with each other. And so I understand why you have a hard time reconciling all of them. But I agree that we generally say consider or address. But we also have these opinions that say that the record has to be clear why the district court rejected each of the non-frivolous arguments. So how, based on this record, let me identify what I think is the biggest concern. Judge Gross says over and over again, and I totally understand why she said this, I'm really concerned that your client has a real serious anger management problem, right? And it seems like that was a significant thing driving the sentence that she gave, which seems totally fair based on the facts of this case. Which does make his argument that I've at least done something to try to address it a pretty serious counter-argument that responds pretty directly to one of the district court's primary concerns about him. And I don't see the district court even acknowledging the existence of that fact anywhere, much less explaining why the court was unpersuaded. Now, let me posit further. If Judge Groh had just said, that was a 1-hour class online and an iPad, it is not nearly enough to overcome all of this other stuff that I've seen about you, I'm sure that would be enough. I will posit that that would be enough. But the district court never said anything like that, and it never even acknowledged the awareness that he had done it, that I'm aware of.
So, Your Honor, in that capacity, I would agree with you that there's nothing expressly on the record, but it doesn't need to be expressly explained away, right? We can look at the.
But how do I know that the district court, at the moment it decided, again, at the moment it decided to vary upwards 2 years above what the government was asking for, that it was actually like, you know, if I'm going to drop the hammer on him for his anger management, I should at least consider or give him some credit for that he has at least now tried to do something about it. Where is the evidence that in that moment the district court was aware of that fact?
Well, Your Honor, I think that we can look at the fact that the district court did state that it had considered, and I know that that is very routine language, but that it considered all of the arguments and the sentencing.
We've got a whole bunch of cases that district
Absolutely.
courts can't immunize themselves from appellate review by saying, I've considered everything you said.
Absolutely. And I think beyond that, the district court did also engage with Mr. Hall during his allocution regarding the prior instances of domestic violence. And in that, she acknowledged that, you know, there was a lot of anger infused in those incidents. Counsel raised during his argument at sentencing the fact that his client had made these efforts. It was interwoven throughout that sentencing hearing. And I think, as Judge Rushing pointed out, you know, we can look at this context where we have numerous domestic violence offenses, violence against women over a relatively extended period of time, and then we can look at, you know, Mr. Hall's acknowledgement that that was due to anger, and then the very recent, admittedly, it was an effort, but it was a 1-hour online self-directed course on which he got, I believe the record reflects, a 90%. And I think that that's a situation where it's patently obvious on the record why that would have been rejected.
Do you agree with the sort of major premise of that this question that that assumes that anger management was a major driving factor behind this sentence? The district court seemed to spend a lot of time talking about how this could have been an attempted murder case, right? That this defendant is lucky he didn't kill someone, and she was very concerned about the incident, and spent a lot of time talking about his criminal history, which included violence and these sorts of related problems. And then when it came to personal characteristics, she mentioned, you know, not only obviously the criminal history, but that not much work and a lot of crime. And she acknowledged his anger management and his anger problems, not managing it, and other issues. But you seem to just accept the premise of the question, which is that, you know, she sentenced him largely because he has anger problems. Do you accept that premise?
No, Your Honor, I do believe that it was a component of a major portion of the sentencing rationale, which was the criminal history and the personal history and characteristics. Looking at how, you know, his personal history and characteristics and the issues with anger management interrelated with his criminal history. But at the end of the day, the driving force, as the district court identified at the sentencing hearing, was the offense conduct, the nature and circumstances of the offense, including details that Mr. Hall actually added at sentencing during his allocution when he explained that, you know, prior to the incident, he had been out drinking and smoking and had then gone, and, you know, the incident occurred after that point. The district court, as I think has been well established today, was heavily focused on the fact that if one of the bullets had been, you know, a little bit to the side, this would not have been a 924C case. It would have been a murder prosecution. And so while I agree that the district court certainly considered you know, his personal history and characteristics and the issues with anger that are infused in parts of his personal history and characteristics, Judge Rushing, you did accurately point out that I don't agree with that premise, and thank you for raising that.
So do you think that the better way to resolve this is on the patently obvious issue or on the central thesis? Because, I will confess, I have a lot of sympathy for our central thesis cases, but I'm not really sure what the central thesis. Do you know what I'm saying? Like, that we have cases that say, like, if you address a central, and that seems right, because if the thing that ties together all of the arguments is one thread, and you say, here's why I don't buy that thread, then that arguably explains why you're rejecting every one of the defendant's arguments. But so just in terms of the anger management course specifically, do you think patently obvious or one central thesis is the less bad way to affirm in this case?
The stronger argument, I would say, is patently obvious.
That it's patently obvious why the district court did not find that persuasive and to not give a lower sentence because of that?
Yes, Your Honor.
And then what about the conditions?
I think I would lean the same way in terms of patently obvious. I think that we can look at the context of it, and I think the other difficulty here that I think was acknowledged, I believe Judge Rushing, you may have raised it, is that how these conditions of confinement, the issue was raised, how it was presented in the sentencing memo, and how it was presented at argument was these things occurred. And that distinguishes it in some respect from United States versus Peterson, the case in which this court, unpublished, looked at a situation in which a district court had not addressed a claim made below, supported by medical evidence, including records of multiple surgeries and a potential future amputation of a pinky that had resulted.
So in that case, it's dangerous for me to be confined here, as demonstrated by the fact that my health needs are not being met and they're going to get worse, right? I think these conditions cases we've seen mostly recently, to me, have all been like, well, they're going away now, but they were the COVID cases. Like, don't send me to that jail. Everyone who goes to that prison gets COVID and dies. Send me to that prison for less amount of time, was an argument that people frequently made during that era. But this is, I take your point that that's more like, don't send me somewhere where things bad will happen. You should send me less time there because something bad is going to happen to me if I go there. Whereas this is a different argument. This is about some bad things have already happened to me, which in a sort of Los Angeles versus Lions style aren't remediable at this point, but you should give me less time going forward because of the bad things that happened to me in the past, which is just sort of an atypical case, I'm realizing.
It's an interesting case, for sure. And I think that, the argument as it was just articulated is a few steps further than the argument as it was raised before the district court, right? As it was raised before the district court, it was that these things happened and it wasn't necessarily tied to anything. And so in
or any of the 3553 factors, like how does this bear on any of the 3553 factors, right?
Or really a request for relief other than that it was in the section regarding, this is my argument regarding sentencing. And I think, as you pointed out with Peterson, there was that element of medical treatment, but there was also this argument of this is a continuing, lifelong, ongoing punishment, and that was part of the analysis there.
Like every day I spend in prison is a day that I spend not getting adequate medical care, and like that's part of the punishment that I suffer that makes me different from other defendants who would, like an additional harm for me.
Sure, the future loss of my pinky, that's something I'm not gonna be able to get back, and you should sentence me to less time with consideration of the fact that I'm gonna live with this for the rest of my life, right? And that was a fully articulated argument regarding why that should be considered as it related to sentencing. Whereas here, what the district court had was a statement of something that had occurred at the Eastern Regional Jail, which is where the Mr. Hall was staying, the United States Marshal's contract with, and Judge Groh expressed concern over what had occurred and indicated that she would also like to really know how that had happened, which I think is a reasonable response to how that was raised. And beyond that, Your Honor, and let me start my outline and make sure I'm hitting everything very quickly. I think as you've articulated, one of the arguments that can be considered here when we're looking at whether or not, in the totality of the record as a whole, the district court adequately considered and then explained the basis for the sentence that was imposed, is the entirety of the sentencing, including whether or not the district court engaged in questioning, whether the district court engaged in the argument, what the district court stated and did not say when it was imposing the sentence and stating the 3553A factors. This is not a case where, the district court imposed a sentence after hearing about mental health rehabilitation and said, and I believe that the defendant would benefit from the opportunity to receive for the first time in his life mental health treatment. the fact that he had taken this 1-hour course isn't inconsistent with receiving formal intervention or formal mental health treatment. Now, one thing that did come up and that I'd like to briefly just circle back to, post-Shields harmless error is a lot harder for the government, at least as it's articulated. It's a bit of a boulder up a hill, and it is a difficult concept. I think it's easier in the concept of the anger management course, right? Because we have this 1-hour certificate that doesn't contradict the district court's findings or the sentence imposed, and then we have all of these express findings as they relate to sentencing. And I think that we could look at that and see, you know, even if the district court didn't expressly state, I am rejecting this, or I've considered it and I don't find it, you know, particularly useful, it would be highly unlikely to have any injurious effect on the sentence. It is more difficult in the concept of the conditions of confinement because there it's really, was it considered or was it not? And as you articulated,
If we decide it wasn't considered, it's not clear how that could be harmless.
if we're saying the district court, you have to consider it and you have to expressly say further than the district court did here, which as has been identified today was a very thorough sentencing. 4 pages of a transcript versus 2 paragraphs is always a nice record to have. For those reasons, Your Honor, and looking at the record as a whole, the sentencing transcript, the memos, the arguments of the parties, the government would submit that the district court considered all of the non-frivolous arguments, that the district court explained the sentence imposed, didn't erroneously consider or fail to consider the 3553A factors, and that the sentence that was imposed was procedurally reasonable. And we would ask that the court affirm. If there are no further questions, I believe I can cede 20 seconds.
Thank you.
Thank you.
Thank you, Your Honor. I want to respond to a couple of things. I want to dispute any suggestion that I think any of these arguments were not tied to or related to any 3553 factors. I think the both issues that we're dealing with clearly go to personal history and characteristics, and I think that it was articulated that way both in the oral argument and both in the sentencing memo. I also think that—
Well, it's a little, you know, I read the memo, and I obviously read the transcript of the sentencing argument, and, you know, it was said, you know, he contracted COVID, he had this attack. You know, that's relevant to sentencing, I guess was the implication. There's no argument made about why it's relevant, how it applies. Now, we can infer reasons, right? It makes sense that it, you know, the court can understand what counsel's saying in the moment. Everyone in the room understands what's being suggested. But doesn't that same reasoning apply to the district court's explanation? That everyone in the room understands what's going on and the context and that she read everything, and we should be able to infer something from what she says too. If we're going to read into counsel's statements all these, you know, understandable arguments that weren't clearly articulated but were probably intended, I mean, why shouldn't we be doing the same for the whole proceeding? It seems to be a bit of a strange double standard.
Well, I guess I would respond in 2 ways, Your Honor. I believe it was clear in the sentencing memo that there was one section devoted to the nature and circumstances of the offense, which I think the court spent a great deal of time on. There was another section in the sentencing memo devoted to personal history and characteristics, and we also mentioned in there 3553B and the relation to what was 5K 2.0 and how the sentencing guidelines don't adequately take into consideration, particularly under 924C, which has just a straight, it's 60 months and no other consideration. So I think that was clear, and there doesn't need to be any inference there. And then also, I think that again, I refer back to this Perez-Paz case from 2021, where It acknowledges, this court acknowledged that the district court failed to address 4 of the defendant's sentencing arguments and concluded by saying that the district court failed to consider these arguments because in explaining its sentence, the district court neither acknowledged nor provided any explanation for rejecting it. And that was quoting from US v. Webb. I agree that this is it would be a simple solution from the court. I think Judge Heitens indicated, I'm sorry that this happened to you, or I think you need some anger management, and this 1 hour course that you took is not sufficient. But, we made this clear. We had a sentencing memo. There were no other attachments to that memo besides the pictures of the defendant with all of his injuries, besides the transcript and the certificates from the other courses that he got. So
Can I ask you about the other courses? Because there was I think an electrical safety course and a CPR course. Are you resting only on failure to address the anger management, or do you think all of those needed to be addressed?
I don't, candidly, Your Honor, I don't think the court would need to address all of them. But clearly, there was discussion about the defendant's anger issues. And I think that the court either, again, we have to guess, either the court considered that or rejected it or didn't consider it at all. It was anger issues of the defendant were clearly a concern for the court.
Right, and you acknowledged that, you mentioned a case where we identified 4 issues, right, that the court didn't explain or address, but the overarching standard we're applying is it's on review, right? We have to be able to understand why the district court did what it did, so we can review it. And it really matters, it would seem, what the supposedly overlooked arguments are, that if the court gives a long explanation for why it did what it did, and there's one sort of minor thing that they didn't specifically mention, maybe we can still review that because we understand why the court did what it did, and because the court didn't mention something, we understand that it wouldn't have changed things. But that analysis might be different in a different context where there's 4 more significant issues, and that seems to be a reason why it's, from case to case, there's some variance between, with how we talk about these. But the overarching standard, right, is that we have to be able to review and understand what the court did so we can ensure that it was appropriate. Isn't that right?
That's correct, Your Honor. And I think if the only issue that the court didn't address was whether or not the defendant's electrical safety course had any bearing on the court's sentence, I think from, if you take what the government was arguing, the totality of the sentencing, I don't think that we would be here. But that's not, as the court has suggested, these particular set of facts and what we're not sure as to whether or not the court considered or didn't consider with regard to these specific issues, I think is what plays here. So I wanted to make that clear. I also dispute that this any suggestion that the district court made it patently obvious that it considered these arguments and rejected them. I don't believe that the district court engaged counsel on either side with regard to any of these issues that we're discussing here. And in the moment and on the brief, I took the court's statement as merely rhetorical. And I see my...
Let me ask you this.
Yes, sir.
We bannered the word considered around. How about, can we use the word aware? Can we get by with aware of something like anger management? I mean, how can we say from this record that judge was not aware of the fact that he took an anger management course? I mean, given all she said, how can we?
I don't think we can take the word aware, Your Honor. I don't think that would be appropriate, because then I think it would allow a district court to just rattle off the 3553A factor and say, I considered this, that, and the
Well,
other
let's
thing.
go a little further. If she's aware of it, obviously has to consider it. And in fact, she just doesn't say anything about it, given this whole record. It just doesn't make a lot of sense to me in this case.
Well, again, I don't know that we could say if the district court was aware of a particular issue that that we could say that the district court considered it in terms of a higher or lower sentence. And then I think, again, that brings us back to the issue about, well, if we can't say for sure, then that leaves this court, even, looking at the record, and even if the court can make some inferences, which, again, I think that the case law requires the court to non-frivolous arguments, to acknowledge them, to say that they've considered them and why they rejected them. If we allow the court to just say, well, I'm aware of it, then a reviewing court, I don't believe, can make a decision one way or the other. Did this district judge consider it in terms of a higher or lower sentence and either dismiss it or reject it as not important, or consider it, and that's why they gave the sentence that she did. So, for example, I don't know that Judge Groh, and I think I mentioned this before, would not have gone higher but for this argument. But the court is left, I think, to guess on that.
Well, I guess I've been doing this too long, because it just strikes me in this particular case, although magic words aren't used, we send the case back down there, we're gonna get the same result. If we've wasted time and energy and money to do that, just because we didn't use the magic word, I considered it.
And I understand that, Your Honor, and it may be true that if the court vacates the sentence, which is what we're asking, and send it back, that it may end up in the same result. But I think that's the reason why we have these precedents that say we, as the reviewing court, need to know what you relied on, what you considered, and what you rejected. And I think that the court's statement also goes to the harmless error argument as well, which I agree in this context, and I think Shields lays that out, that there's error and in this regard, and it can't be harmless. I'm over my time. If the court has any other questions.
Thank you, counsel.
Thank you.
We'll come down and greet counsel after our courtroom deputy adjourns court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.